Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-decision episode of SCOTUScast. I'm your host, Grace Gotchling. On April 6, 2020, the Supreme Court, by a vote of 8-1, held that reasonable suspicion for a vehicle stop exists where the officer is informed that the registered owner of the suspect vehicle has a suspended driver's license. In an opinion written by Justice Thomas, the court reaffirmed its decision in United States v. Cortez, a 1981 case, when it wrote that for an officer to initiate a brief investigative traffic stop requires, quote, a particularized and objective basis for suspecting that particular person stopped of criminal activity. And now, to discuss the case, we have Brian Fish, Special Assistant United States Attorney, Baltimore, Maryland.
The case at hand, I remember going to the November oral arguments and sitting through this thinking, what was the Supreme Court of Kansas thinking? It didn't make any sense on why this case would have been denied by them. And now after reading Justice Thomas's majority opinion and the concurring opinion and Justice Sotomayor's dissent, I'm now thinking, what is Justice Sotomayor thinking? Because in neither case does it make any sense. There's simply no logical point to the reason why the case was denied by the Kansas Supreme Court, or much sense in what Justice Sotomayor was, I guess, trying to convey in her dissent. Basically, when I was sitting in the courtroom back in November, trying to think of a great sports analogy, this case had essentially been tried 12 times, in the sense that between federal courts of appeal and state Supreme Courts, this fact pattern had come up 12 times, and the government went 12-0. So this was the 13th time this game was played, and for some reason, the state of Kansas, their Supreme Court, thought that it should go the other way. So let's give you a brief rundown of what the facts were in this particular case and go to Justice Thomas's decision. The case out of Kansas was at the motion to suppress stage. Parties stipulated to 7 facts and 7 facts alone, and based on that stipulation, the trial court in Kansas granted the defense motion to suppress. So let's talk about those 7 facts. Let me scroll back up. And fact number 1, that deputy in the case was a certified law enforcement officer. Number 2, that on April 28, 2016, the deputy was on patrol when he observed a 1995 pickup truck. And fact number 3, he ran the plates on the pickup truck. 4, the run comes back that, in fact, the plates do belong to said 1995 Chevy 1500 pickup truck. The next fact, the truck is registered to one Charles Glover Jr., and that Charles Glover had a revoked driver's license in the state of Kansas. Next fact, the deputy assumed, and that's where the fight begins, the deputy assumed that the registered owner of the truck was the driver. Fact number 6, the deputy didn't observe any violation. He didn't attempt to identify the driver. He simply pulled the driver over, and when the deputy approached the vehicle, the driver of the truck was identified as Charles Glover Jr. That was the entirety of the evidence before the Kansas trial court. Again, the trial court granted the motion. The state appealed. The Kansas Court of Appeals reversed. Glover appealed to the Kansas Supreme Court. They reversed it again, Kansas appealed to the Supreme Court, and earlier today, in essentially a 6-2-1 decision, the majority authored by Justice Thomas, Supreme Court reversed yet again and sent the case back. So let's talk about what happened, first of all, at oral argument, and then how it played out in the three different decisions today. Oral argument, standard issue, Kansas went first in this one. They got their 2 minutes in before the justices started firing off questions. The highlight of that colloquy was when Chief Justice Roberts asked a few questions which were alluding to a statistical norm. What is a reasonable suspicion? Is there a number? It went back and forth, but nothing really came of it substantially. He then, when it came time for Glover's counsel to argue, this is when the Chief Justice essentially pounced. He asked Glover's attorney the following: is it reasonable to suspect that a owner of a vehicle is the driver of a vehicle? And what's the percentage? I'm paraphrasing here. Is it 5%? The counsel agreed. Is it 10%? The counsel agreed. Well, then, what exactly is the definition of reasonable suspicion? Is there a statistical norm for reasonable suspicion as opposed to, say, probable cause or proof beyond a reasonable doubt? And Chief Justice goes back, has this colloquy with defense counsel, and essentially what he comes down to is this. Reasonable suspicion does not have to be based on statistics. It does not have to be based on specialized experience. It is based on simply common sense. And that's the key to the case. As a police case in the vernacular, TKE, the training, knowledge, and experience of the police officer, how does that apply to a reasonable suspicion fact pattern? And is the TKE, the training, knowledge, and experience, required to be shown in every reasonable suspicion stop, essentially in every Terry stop? The answer to that at the end of the day is no. And here's the best line from today's decision by Justice Thomas. Justice Thomas takes the task of the dissent, and here's the best line of the day. Justice Thomas states, the dissent's definition of common sense defies common sense. And if that doesn't give you at least a guffaw here today, nothing will. He essentially is saying that if you look at Justice Sotomayor's dissent, what she is saying is that in every single case, the government, the police officer, if you will, but certainly the government prosecutor would have to show that the stop for Terry stop purposes the government would have to show that the police officer has some specialized knowledge about the area in the case of the Terry stop, or something additional about, in this case, the driver of the vehicle on a car stop. You would have to show some additional piece of evidence other than just what everyday non-police officer common sense is. And the Chief Justice simply shoots that down. We do not have to essentially bifurcate a police officer. His everyday common sense does not have to be overcome by his common sense as a trained police officer. In other words, we don't have to show that the police officer has 20 years of experience and 1,000 car stops, and in his particularized training, knowledge, and experience that, say, police vehicles with being driven on the road tend to be driven by their suspended owner. You don't have to show that. What you simply have to show is that in everyday common sense world, that if there's a car, it's reasonable to suspect that car, or in this case, this pickup truck, was driven by the owner of the pickup truck. And that's it. And as Thomas says, the dissent is throwing away the common sense definition of common sense. Now, we've hit upon the 12-0. I have to throw a sports reference out there because as a college basketball junkie, today was supposed to be the NCAA championship game, and I'm brokenhearted to be missing out of all the sports things that have been missed so far in the last 3 or 4 weeks. That's, to me personally, the crushing one. And so this is the 13th time, essentially, this game has been played. And Thomas essentially slaps down both the Kansas court and the dissent. And so the government in this particular fact pattern has run its record to 13-0. Justice Kagan and Justice Ginsburg join in a concurring opinion written by Justice Kagan. Their concurrence essentially adds one additional fact that the majority simply didn't take into account because from their perspective, it didn't really matter. But essentially, Justice Kagan is stating that based on additional information gleaned through the record, but not necessarily at the time of the initial motion to suppress hearing, that in Kansas law enforcement, they almost never revoke a license except for either a serious offense or repeated offenses. And therefore, based on that additional piece of knowledge, whether it was known by the deputy in this particular case or not, we don't know, but essentially they're adding this to the fact milieu and going from there. But anyways, because that's the case, that Kansas doesn't revoke people unless you're really, really bad, that when the deputy made the records check, found out that it was Glover's pickup truck and that Glover had a revoked license, it must have been revoked for a really, really bad reason. And therefore, that additional piece of evidence, if you will, was good enough for them to at least concur in the majority opinion. Justice Sotomayor, in her totally one-off, no one joined in her dissent. What she's essentially saying, as best as I can glean, is that she's accusing the majority of simply filling in what she calls the police officer's hunch, and the majority is simply filling in the hunch with the phrase common sense to get the government essentially over the hurdle of a bad car stop. And she, based on her interpretation of the difference between hunch and reasonable suspicion, is voting to dissents from the majority opinion and would vote to uphold the Kansas Supreme Court's decision. But in her cases, I felt that she lacked the articulation on how she's using the cases and their holdings in the proper way. What I mean by that is specifically the Navarrete case, which Justice Thomas quotes with some effect in his majority opinion. She gets the completely wrong holding in the case, not from the underlying who wins, who loses, but from what the case is trying to hold, what the case is telling us law enforcement should do in a particular circumstance. She just gets it wrong. And she does that on a couple of other cases where she's inferring things and reading into cases that you read the case that she's discussing, it simply doesn't say that. So that leaves me back to, what was she thinking? And quite frankly, I don't know. So what we have here today is a couple of things try to get clarified by the majority. And here's the takeaway from the case. If what Justice Sotomayor is saying, or at least what I'm inferring what she's trying to say, is she wants reasonable suspicion to be almost to the height of probable cause if there's a number to be given. If, say, beyond a reasonable doubt is in the mid-90s on a scale of 1 to 100, and probable cause is somewhere around 50%, where should reasonable suspicion lie? And she would have it, if you read her dissent, almost to the level of probable cause. And that's just simply an incorrect position to hold. Obviously, by definition, lots of pun intended, reasonable suspicion is a much lower burden for the government to show a reason for a good stop, if there's reasonable suspicion for a brief encounter for the officer to ask a few questions to figure out, is there criminal activity afoot? Thus the Terry stop and thus the Terry frisk is a follow through on that. Well, if we have reasonable suspicion at a much higher standard than simply common sense, then if you believe Justice Sotomayor, she would almost eliminate the possibility that it was in fact lawful activity, in which case the officer would simply say, thanks for your time and have a nice day. And just because there's a more probability in a reasonable suspicion stop as opposed to a probable cause stop, there's more probability that there was in fact lawful activity being engaged upon by the person stopped, doesn't necessarily make the stop unlawful. That's the reasonable suspicion for a short, brief encounter as opposed to probable cause to make an arrest. And based on her decision, it appears to me that she's essentially equating the two, which is simply not the law of the land. And for those reasons, I think coming full circle with the sports analogy, it's now 13-0. This, at the end of the day, a car stop for a brief encounter is pretty much going to be allowed, if you will, when there's a revoked or suspended license kind of case. Unlike what Sotomayor is asking for, the police officer doesn't have to speed up and get next to the suspect vehicle, look in, and when he's told that Charles Glover is a middle-aged man and he sees a teenage girl, he has to then break off pursuit. None of those kinds of things will be required of an officer. If the officer simply calls in, gets the license plate to match the car, and the car comes back to a person with a suspended license, that's going to be a good stop. And for those reasons, I think, folks, that the 8-1 decision, it wasn't that close.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.